Hello, hello, hello. Looks like we're back with a verdict. We'll make sure that we are not missing sound. I think they just haven't turned it on yet.
Sorry.
Well, yes,
Okay, thank you.
Juror number 11.
I'm sorry. I apologize. I was looking at the other juror.
Juror number 11, was that and is this your verdict? Mr. Smith?
Yes.
Juror number 12, as follows.
Ronald Francis Grady, 2572.
Okay, here it is from the beginning. Sorry. I didn't have the sound on.
Court recalls the matter of people of the state of Michigan versus Ronald Francis Grady, 2572-51 FH. Members of the jury have returned into the courtroom, and the court has been advised that the jury has reached a verdict in this case. Ms. Hatch.
Members of the jury, have you agreed upon a verdict? If so, who will speak for you? Will you please stand? Madam Foreman, how do you find the defendant?
We, the jury, find the defendant, Ronald Francis Grady, as follows. Count 1, guilty of the offense of witness retaliation.
Members of the jury, listen to your verdict as recorded. You do say upon your oaths that you find the defendant, Ronald Francis Grady, as follows. Guilty of the offense of witness retaliation in manner and form as the people have in their information in this cause charged. So say you, Madam Foreman, so say you all members of the jury.
Is that correct?
Correct.
Ms. Sitt, would you like the jury?
Yes, sir. We'll
Sir,
go
you
by-
need juror number 1.
Yep. Juror number 1, was that and is this your verdict?
Yes.
Juror number 2, was that and is this your verdict?
Yes.
Juror number 3, was that and is this your verdict? Juror number 4, was that and is this your verdict?
Yes.
Juror number 5, was that and is this your verdict?
Yes.
Juror number 6, was that and is this your verdict?
Yes.
Juror number 7, was that and is this your verdict?
Yes.
Juror number 8, was that and is this your verdict?
Yes.
Juror number 9, was that and is this your verdict? Juror number 10, was that and is this your verdict? Juror number 11, was that and is this your verdict?
I'm sorry.
well, yes,
I like her
Juror
style.
number 11.
I'm sorry. I apologize. I was looking at the other juror.
Juror number 11, was that and is this your verdict? Mr. Smith?
Yes.
Juror number 12, was that and is this your verdict?
Thank you. Court accepts the verdict of the jury finding the defendant guilty of the charge contained in the information and direct entry of judgment to the charge contained therein. Honey,
The people at this time would move to reapprove, Your Honor.
you may proceed.
Your Honor, the people will propose for exhibits 3, 4, and 5 pursuant to MCL 769.13, a certified criminal history certified by the Michigan State Police, a judgment of sentence from this honorable court, as well as a pre-sentence information report from the Michigan Department of Corrections for the same offense, which also shows those prior offenses.
And those have been marked.
Not as of yet, Your Honor.
If they do.
Oh, this guy's got a record. Which is why I didn't testify. Because the attorney said you don't want to go up there and tell your side and then have the prosecutor list off all your convictions to this jury. Yeah, that's my thought on this.
Thank you.
I don't know if anything else happens. I just want to get through it.
Yeah,
Yes, you may.
Or with the admission of said exhibits, the people have proven beyond a reasonable doubt and met our standard that the defendant was a habitual fourth offender.
With any objection to the proposed exhibits? Thank you. People's 3, 4, and 5 are admitted, indicates in People's Exhibit 3. The defendant on February 12, 1981 had been convicted a felony larceny over $100 at jury trial. That was on 2/12/1981. In Peoples 4 indicates the defendant was found guilty at jury trial March 1, 1984 to delivery of a controlled substance less than 50 grams. There were 3 counts. In People's Exhibit 5 indicates the defendant was convicted again of those 3 counts mentioned just a moment ago, making this habitual fourth, and the court so finds habitual fourth has been established by the people of the state of Michigan. Court was scheduled sentencing in this matter for December 15, 2025 at 9 a.m.
Ouch.
Prior to sentencing, I'm ordering a pre-sentence investigation report to be prepared, provided with both counsel and the court at least 2 days prior to sentencing. Sentencing guidelines shall be scored 14 days prior to sentencing, provided to counsel. Any objection to the scoring of the guidelines must be filed in writing with the clerk of the court no later than 7 days from sentencing. Any objection to the scoring of the guidelines must also be providing that information to adult probation. The defendant must appear in the courtroom at time of sentencing. If there's any supporting documentation to the court, it must be submitted to the court no later than 7 days from sentencing. Any objection or written response must be filed 3 days thereafter. We'll address other matters in just a moment, but I'm going to excuse the jury. Members of the jury, I wish to thank you for your attention throughout this entire trial. I appreciate you honoring your summons and being here today and providing a very important service. It's a commitment. That is sitting as a member, peer in our society, judging our fellow citizens relative to criminal charges or any charge or any civil matter that may be brought before the court. I appreciate your time throughout this. If you need any documentation from us, as soon as you are excused, feel free to ask Ms. Hatch or Ms. McNames, and we'll provide that to you. As I stated before, you will not be called back again. Your jury service has concluded, and the checks that will be provided by the clerk's office will be sent for probably the end of the term, but
It'll be soon.
it'll be sooner than that. So you'll say the check is in the mail. We will get that to you. Again, at this point, you can discuss the case with anyone. You don't have to discuss it with anyone if you don't wish to, but I'm going to excuse you this time. Thank you for your time and attention. You're all rise, please.
Well, there you have it. That's interesting. That is interesting. I messed it up, so we got the verdict about a minute late, but still, we got it all done in one day. That was fascinating. By the way, I have a whole bunch more clips I'm going to do now because I thought we were going to have to wait for it. I didn't know that I would have to pause, although I should have anticipated it, but I didn't know I'd have to restart the stream 2 times to get this thing done. But we got it done. And it makes me all the more convinced that it really was a threat. I mean, he's a low-level thug. They're old convictions, but this guy's not afraid to commit a felony. The judge there is saying, so the judge is saying it's a habitual fourth. I don't know what it is other than that's going to jack up the sentencing, I think, significantly. So this is not a small deal. I mean, I can't give you the specifics. I should have one of my Michigan prosecutors on. Steve Vincent, Jessica Blanche, Deborah Davis. They come on here and put you some real knowledge about what that means. But that's not me. I don't have them available at the moment. I don't have them handy. They're not in the room. So that's pretty wild. But it makes me think, yeah, this is bad. I wasn't a huge fan of hers anyway, and it's not the end of the world, but it also makes me like the woman even less. She knew this guy had a record. It was her husband. She knows what he's capable of. And she either allowed it or straight out encouraged drama between these two because she wanted it. Sorry. It's not her fault, but I'm just saying she's not an innocent party here. That's what's going on. She probably doesn't have any respect for the simp that picked her up after the fact and thought it would be fun to watch these two fight it out over her. Just for the drama of it. Now, ultimately, this guy's the bad guy, but if you think that it wasn't serious or he didn't actually come after this guy, I mean, that is when you tell me that that you get shoulder checked. I mean, it depends on how it is, but the way he described it, I thought the second husband, I thought he was very credible on the stand, and yeah, this guy's trying to draw a confrontation, and why? Because he's got a record. He doesn't give a shit. His life is crap. It's never gonna. You know, he can't get anywhere. He's a convicted felon. That's his swamp. The other guy's trying to. My guess is trying to live a normal life. He's got more to lose. You can't enter that fight. That's how these things work. All right. Anyway, we got some fun stuff. I mean, since we're here, and I'm out of. I'm out of starts for the day, so let's use the clips we have. I got some good stuff from Zach and Brecken as usual. Let's go.
Brendan Swanson. You step right in front of the TV there. Yeah. Up
Mr.
here,
Swanson.
right up there, front of her.
Hi, Mr. Swanson.
Hello.
Hi, I'm Judge Hamilton with the Amarillo Municipal Court. Way back in September, you were charged with a public intoxication at Southwest 4th and Rusk. That's a Class C misdemeanor punishable by fine. The fine range is $1 to $500. You've been in jail a long time, so your time served on it. But you can plead not guilty, no contest, or guilty. What do you want to do?
I don't remember the incident, to be honest.
Let me tell you what I have. Okay, I got to put my glasses on. That's a good question because you've been here a while. It looks like on.
I love the honesty, Judge. I in fact, I think I was with Cooter Brown that night, but I don't remember. We were both wasted.
Well, this says.
I may have had a couple of 2 or 3 beers or something.
It's
I don't
possible.
know.
Well, hold on. That one's from September 8th. Oh, hold on. Let me grab that one. I've got your new arrest on there. So let me go back to this one. And that'll help refresh your memory and mine. So give me just a second.
I haven't done anything to be arrested for.
This is from like September. This one's from September.
And it was drinking?
Yeah,
Okay. I probably did have a little too much.
maybe, right? Okay, let's look and see. So on September 8th at Southwest 4th and
Okay, I mean that's kind of charming. I probably did have a little too much. I mean, like I don't remember it, but just just knowing myself, I think probably yeah.
Rusk, it says they were patrolling the area. Oh, you were standing in the middle of the street. Officer
that
made
really?
contact with you, huh? What?
Was I really?
That's what it says. They immediately observed your speech to be heavily slurred, slight odor of alcohol. You had extreme difficulty standing and couldn't walk on your own without assistance. You went to jail for this last time, but you bonded out and then you didn't come back to court. So this is just that one from September.
Oh, okay.
Does that sound more familiar? About 9 o'clock at night?
I honestly don't remember any of that, to be honest.
I think they took you to the hospital.
No, this isn't AutoZone guy. AutoZone guy is just as bad, but they're two different guys. They probably know each other, but don't remember it.
First, made sure you were good, and then they brought you to the Randall County Jail, and then you bonded out.
They probably had me on some kind of antipsychotic drug or something. I don't know.
Right. Yeah, this was like a month and a half ago. So your time served on it, but you can plead not guilty if you want to. But this time you'll have to get a surety bond because you didn't come to court last time when you were supposed to.
How do I do that?
Well, you'd have to call a bondsman, put up a bond.
How much does that cost?
I don't know, but you can plead guilty or no contest and you'd be time served.
Well, if I plead guilty, what happens then?
Your
I
time
haven't done
served. Then your time
Huh?
served. Then your time served. And it
I-
means you just go. You just leave. You don't have to come back.
I guess I'm guilty of something,
Okay.
but I haven't done anything wrong.
This is the one from Southwest 4th and Rusk.
He's guilty of something, but hasn't done anything wrong. I might steal that for my next album.
It says that they observed you standing in the middle of the street. They made contact. Your speech was heavily slurred and you had a slight odor of alcohol. You had
Okay,
extreme
well-
difficulty standing and
Somebody get me a song. I'm guilty of something, but I haven't done anything wrong. Clearly, it has to be country.
couldn't walk on your own without assistance. And they said you were obviously intoxicated and a clear danger to yourself due to your level of intoxication.
Okay,
At-
well, I'm sorry, that'll never happen again.
Okay, so do you want to plead not guilty, no contest, or guilty?
But what's the best thing? Not guilty?
If I'm being honest with y'all, I think it will happen again. I don't know why. Maybe it's just my spidey sense, but I think it will happen again.
If I told you which one to do, I'd be your lawyer, and I'm not your lawyer.
I
So,
know, I don't know I don't know what to do. I guess not guilty because I haven't done anything.
okay, well then I'm gonna have to see in a couple of days. But so between now and then, your job, when you go back to your pod, your job is to be contacting bondsmen, okay?
Right this way, Swanson.
Huh?
I'll see you in a day or two.
This way.
I don't know what happened to my phone. My phone has disappeared.
They'll give you the opportunity to make a phone call to a bondsman.
Right this way.
Oh, he needs his phone. His rotation misses him. Seriously. I can't decide if he appreciated what he just did or not. He might just be homeless and want a place to sleep. But, pleading guilty has zero consequences. The guy's had been convicted of it so many times, and he could just walk out today. And he affirmatively chose to stay in jail.
Thank you.
Thank you, Mr. Swanson. Thank you, Deputy.
Thank you, Judge.
I still got, I went ahead and set Swanson outside because he kept moving around.
Well, he was having issues with his feet. Thank you.
He's back, baby. Look at that. We got a multi-appearance edited setup. This is awesome. Thank you, Brecken and Zach.
Right here so you can hear her, okay?
Hi, Mr. Swanson. How are you today?
Hi.
Hi.
It looks like your flip-flops were bothering your feet.
Oh, they have a hard time staying on. Yeah.
I would have a hard time with them too. Hey, we need to talk about that public intoxication charge from September 8th. You can plead not guilty, no contest or guilty. What do you want to do?
I don't remember the deal, to be honest. I may have been. I honestly don't know. I cannot remember that far back.
Yeah, we've already talked to you about this before. It was at Southwest and
I
South Rusk.
didn't hurt anybody or anything. I don't
Yeah.
think I did.
That's not what the charge is. It wasn't that it was that you were publicly intoxicated. And
I think that deal is so far gone. It's nothing to do. It's not going to happen again.
okay, well, we still have to resolve this. So let me tell you what their notes say and then see if that refreshes your memory, okay?
Yeah.
Okay, give me a second. Let me pull up their notes.
Can I sit down here a minute? I'm awfully tired.
Yeah, just a second. I know your feet hurt. Okay. So it says this was on September 8th, so it was like 6 weeks ago. It's that you were standing in the middle of the street at Southwest 4th and Rusk, and that your speech was slurred and they could smell a slight odor of alcohol. You couldn't stand and couldn't walk on your own without assistance. And they said you were obviously intoxicated and that you were telling them you didn't know where you were and you had trouble comprehending basic requests. So that was about 6 weeks ago. Your time served on it, so you can,
Probably did have a little too much.
okay. Do you want to plead guilty or not guilty?
What if, I don't know, if I plead,
I mean, I believe this guy. He literally said exactly the same thing in the last hearing, and he doesn't remember it. So he's just going back to the playbook.
guilty, what happens?
Nothing, you'll be done. If you plead not guilty, you got to come see me tomorrow.
Okay, I don't have any way to get to you, I don't think.
Well, you
Just
can plead
Plead, what was the first one? Guilty or not guilty?
guilty.
Guilty. Okay, I'm guilty.
If you plead guilty, I'm going to find you guilty and then your time served, okay?
Okay, thank you.
Thanks, Mr. Swanson. You have a good day.
Thank you. We done?
We are done.
So do I have any more contact with you?
And not unless you get put back in jail.
Yeah, okay.
Okay, thank you. Thank you,
Thank you.
Deputy.
The judge had to hold back from saying, "Yeah, we done." That was fun.
Your name, sir? You have to start your video and state your name.
David is Stillard.
All right. So I've got a charge, and it was fair to attend the court work program on September 27 of 25. I adjourned it and said you could appear by Zoom. Again, I'm going to offer you the right to a lawyer if you want one. Would you like an attorney?
No.
Do you wish to have a hearing, or do you intend to plead guilty on this?
Hearing.
Okay, let's get in Ms. Tassino in here, John, real quick, and we will have that hearing. Okay, the charge, again, you understand, is fair to attend the court work program on September 27, 25, correct?
Yes.
All right, and you know that I entered a not guilty plea for purposes of arraignment, correct?
Yes.
What's her number again?
He said she's wrapping up an appointment. She'll be right.
Mr. Estolart, you just stay right there. I'm going to go on to another case. The probation officer's finishing up an appointment. She'll be right in. You can just stay right there. Derek Paul Lopez, 25B149536 A, B, and C. Come on up to the podium, sir. Your name?
Derek Paul Lopez.
You're charged with disobeying a police officer, directing traffic, resist, hinder, and obstruct an officer, and also careless driving. Ma'am, can you have a seat? I'm sorry. Can you do that, please? You have the right to a lawyer. You have 3 charges here, 2 of which are misdemeanors and 1 of which is a civil infraction of careless driving, a 3-point violation. Do you understand that? Would you like an attorney to represent you? Okay. We'll set you up with a lawyer. You can go out in the hallway and you will be patient and you will be appointed a lawyer. But I do have to say you have another charge here from the same date. It's 25B149537, which is defective equipment window tint. So 4 filed. We're setting you up with a lawyer. You go out in the hallway and he'll bring the file and get a lawyer to you, okay? Just be patient. Thanks. People against Baldridge, Miranda Rose Baldridge, 25B149433 A and B. Baldridge here, come on up. Your name, ma'am?
Baldridge.
You're charged with a misdemeanor offense of leaving this. Where's your lawyer? Is Mr. Zayed here? Lisa?
No, not on Zoom. That file should have been with Caitlin until he came in.
Okay. Ma'am, go have a seat, okay? Thank you. All right, Jen, this has to go to Caitlin. People against David Istolart Gonzalez, 25W836565. Your name again, sir?
David is still alert.
Ms. Tessino, your name?
Emily Casino.
He pled not guilty at the initial hearing. I don't remember why I adjourned it. I think you might have been out.
Here, I just didn't get in for quick enough.
Well, we're prepared to go with the hearing. Are you ready to testify?
Yeah.
Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
Definitely.
All right, go ahead.
I have the report right here for the work program dated September 27th of 25. He was a no-show. There is a note that he showed up at 8:55 a.m. But because he was late, they locked the doors at 8:35. He was not permitted to work. Therefore, he wasn't able to complete the work program day.
Do you have any questions of her? Mr. Istolart,
No.
do you wish to testify or remain silent?
Testify.
Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
I agree. Yes.
You do?
Yes.
Okay, go ahead. Tell me what you'd like to say.
There was a car accident which was completely out of my control, and I had to circle around trying to get there. I know it's just a 5-minute thing, but I did show up there.
Where was the accident?
I think it was around before 4th Street, and I'm not from the area.
4th Street? What's 4th Street in Trenton?
No, not Trenton. I don't remember the name of the street, to be honest.
Well, why were you 25 minutes late? That's a long time.
No, I don't know why it says that. I arrived at 8:40.
Who wrote 8:55?
Yeah, I don't know what supervisor was working that day, but he said he showed up late around 8:55.
All right.
He was notified that he could not work today.
No, and he even told me we're on camera. So I'm pretty sure I checked my watch. It was 8:40.
I'm going to find you guilty as charged of failing to attend the court work program. You have to get there on time. I will have you do anything else you'd like to say? That's your first technical violation. Anything else?
No.
Pay additional costs of $100. Serve an additional day on the court work program. So you're going to have an additional day to be on the court work program. You want to talk to him and pay $35 for that. So you owe $135.
I'll send an email.
All right, she's going to email you. You owe $135. Can you pay that today?
No.
When can you pay that?
Can it just be added to the tab?
Put it on my tab, Judge.
Well, $100 weekly?
And I'd like a lime with that,
I have expenses.
not a lemon.
Yes.
Lisa, just add that to add these fines costs in system, and he can pay at the same rate, okay? All right, that's what I'll do, Mr. Istolart. So she's going to email you and schedule your court work program. Did you say something, Lisa?
Yeah, just so you know, he's not up to date on the payment plan. He's making $1 payments, it looks like.
$1 payments.
He paid $100 on September 15th, and then we received $1, another $1.
Big spender.
What? $1? You paid $1 on October 14th?
No, I paid 100.
Look at the look at disgust. I love it.
When did he pay his first 100?
September 15th.
And they paid 50 on October 7th, right?
Yeah, and then $1 on the 14th.
Why would you pay $1?
Then I got $1 again on the 21st.
Why would you pay $1?
No, I just click and pay the $100.
Well, check your bank account, sir. Maybe you can see what happened.
You're saying you made two $1 payments.
Yeah, I have a $1 payment on October 21st and a $1 payment on October 14th.
I have the payments on the screen, Judge.
That's what it says. Restitution on your credit card.
It might have been the financial institution checking. I don't know. I haven't seen this. If it's the same date as other payments, but if it's just randomly on its own, that's really weird.
Why would you pay $1? Tell me why you would pay $1. I just want to know why somebody would go on a credit card and pay $1.
No, I need to check on that, but I clicked and I'm pretty sure it said 100. I don't know why it said $1. I don't know if there's a hold on the credit card or something.
A hold on the credit card? What do you mean?
Like a pending charge or something before it releases the money. I don't know how that works. But I paid $100 online.
Well, you better provide us with proof quickly. So I would check that now. Are you working?
Yeah.
Ask you a question.
Yes, Judge.
Why would you do this?
What time? Today?
Since 7 a.m.
You're at work now?
Yeah. Well, I mean, I requested time off. I work from home. Sometimes I go to the office.
Well, you better check it. Okay?
Okay.
I mean, we don't make mistakes like that. That was October 14th and 21st. I mean, I'm not really amused if somebody's doing it on purpose. I mean, I guess I got to have a better sense of humor. But I can't imagine somebody paying $1. So you provide us with proof that you paid 100 and we'll adjust. But we don't make mistakes like that. All right. So you better take care of that real quick or you're going to have another show cause pending.
Okay.
Good luck.
Thank you.
All right.
Case, People versus Whitney Mitchell.
Judge calls for people.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Miss Mitchell. State your name for the record, please.
Whitney Mitchell.
You take your hands out of your pockets. All right, what are we doing?
We're here for a pretrial. There's also a bond violation report.
Yes.
Um,
Go ahead.
so given the results,
Do you have a bond violation? What?
I can
Go ahead.
So there's a couple of things, I guess there's three kind of things to address here. The first is the cocaine. I did talk to Miss Mitchell about it. She did test the day after her arraignment. She denies using cocaine after her arraignment. This was her first test after being ordered on bond. And her arraignment was on the 17th and the test was the 18th. So her assertion is that it was from prior to given the bond conditions. Regarding her use of cocaine, however, she has seen a doctor at the University of Michigan where she is beginning the process to enroll in treatment there. She has an appointment tomorrow at 2:30. And they are, the letter that she provided me that's dated today says that They've spoken with the addiction treatment team and are working to place her into intensive treatment and detox services. And tomorrow will be the follow-up appointment. Regarding the THC, she does have a medical marijuana card and did provide that to community corrections. And
What about a diluted sample? Go ahead.
yeah, the dilute is the third piece here. I asked her about it. I also tried to get kind of a definition from community corrections. I didn't receive one, but her explanation was that she woke up, didn't eat anything, drank some water, took her kids to school, and then went to community corrections, as is her normal routine. She didn't have any insight into what happened, and I don't know why. We both don't know why it would be diluted. We have no explanation for that. She was very clear with me that she did not try to skirt community corrections or anything like that. She said she wouldn't even know how to. So given all that, Your Honor, my request is to keep her out of custody, let her go to this appointment at the University of Michigan, see if they can get her into treatment and detox. She is employed. She has 2 jobs and a young child. She works at the University of Michigan and at Five Guys. How old's your son?
He's not young, he's 15, but I still care for him every day, drive him back and forth to school, cook him dinner.
This is that's an individual with
Yeah, she's head of the physics department.
have a second offense operating while intoxicated at this point on this case. That is alleged to have occurred back in June. And I have a test result that shows up on the 18th as positive for cocaine. Her next test, though, is a diluted sample.
Can I speak?
Yeah.
So what that was, I wasn't doing any drugs like cocaine or anything. I was smoking marijuana, and then I'm like, I remember I called.
I think I did this. We might have a multi thing here, or maybe they're just repeating themselves. But I recall having this very go around with her. But there's more here.
And asked, is it okay if I can smoke? And they were like, we don't know. Then I found out yes. So I drank some bottles of water before the test, but I didn't do any hard drugs or anything. And I just really want to stay out so I can keep my jobs and stuff. And I can, because if I lose the job, then I won't be able to go to the treatment because I won't have the insurance.
Yeah. It's a horrible circle you placed yourself in.
Yes, it's all my fault.
Oh, it absolutely is all your fault.
I have a problem and I'm willing to try to get it fixed now.
Is that before or after you kill somebody with a car? This is your second offense, or at least alleged second offense.
Your Honor, I don't plan on killing anyone. I really plan on.
Nobody ever does.
Okay, I'm sorry, Your Honor. I just want to stay out for my son and my job.
So when you were doing the cocaine, how much were you thinking about your son?
I wasn't thinking. I was thinking about myself then, being selfish.
So why are you bringing him up now, saying you want to be out with him when you weren't thinking about him when you were doing the cocaine?
Because to see the look on his face when I told him I was coming, and to think to prioritize that stuff ahead of him, and with the good stuff I finally do have going in my life. When I start doing good, I just want to be on a straight and narrow and get clean and stay out. I don't want to have to start from scratch. No, you're my mercy.
Okay, I'm assuming that's a yes. Can I ask you a question?
Here's the thing I don't get. The test results from June 30th show in her system alcohol, methamphetamine, and cocaine. That's at the end of June, very beginning of July. So you're sitting up here telling me you're sincere about this, invoking your son, doing all of that stuff, yet 3 months later, or a little less than 3 months later, I still have cocaine in your system.
It's an addiction problem.
What?
It's an addiction problem.
So when exactly did you figure that out?
Now I'm going through all this stuff.
Yeah, you want to get here. You're an addict. You're going to get here and try to tell me anything and everything in the world to try to keep yourself out of trouble and keep from being accountable. That's what you're doing.
I just want to keep the positive things going in my life. I'm willing to admit my wrongs. Like,
Anything else?
Well, Your Honor, I'd ask that you take into consideration the fact that she does have an appointment tomorrow to address,
I don't know what
addiction.
game she's playing. She's playing a game.
if the court
If she was really serious about it. I mean, what right now is causing her to do all of this? Being in court? Well, she knew she was headed there from the time that she got stopped on this. And why is it taken over 30 days from the time of her arraignment for all of a sudden for her to have this appointment?
I work 2 jobs. I just don't want to lose everything.
And Your Honor, we have been in communication. We talked about this. She's willing to do treatment. I think she's admitted to the court that it would be helpful for her. I agree. On a lot of these cases, it's helpful, right? I guess I'd ask the court take that into consideration today. If the court does remand her.
I don't know what she's going to do the moment she walks out here. I have no idea.
I'm going to go to work.
I have no idea what she's going to do. The sad fact of the matter is, I don't think she does either. Because the cold hard reality is, June, she's picked up. She has cocaine and meth in her system, as well as alcohol. So I'm surprised she's not dead. She has a previous drunk driving before that. So between the end of June, so let's just say the beginning of July, coming up into September, she's still using.
Yeah.
And then when all of that kind of catches up with her, now I'm going to get myself enrolled in treatment, or I'm going to get myself enrolled in this. But even from the point of the time that she first saw me on the 17th of September till now, she hasn't done anything. Really. She's got an appointment tomorrow. How come that appointment isn't taking place 4 weeks ago, if not 3 or 4 months ago, quite frankly?
Oh. I just work so many hours and just try to take care of our kid. I should have made it 3 weeks ago, but I'm trying to take.
You got an excuse for everything. Yeah. Everything coming out of your mouth is an excuse.
I just want to do better.
If I am able to communicate with the doctor and coordinate some kind of plan moving forward, can I submit that to the court for your consideration?
Certainly you may, but you know, you can have a plan, but then she's gonna need to do it. Cause I'm gonna tell you right now, she's coming before me, she's telling me everything that she's telling me, but she's lying to me like she's been lying to everybody in her family and everybody around her for I don't know how long, but certainly over the last year. Well, young lady, game's up. You may have just run into the immovable object. If you're going to tell yourself that you're going to do this, then you're going to do it. But you're not going to come up here and just kind of give me this and that. And I'm going to do this and this is why and everything like that. If you want to make a commitment, then you make the commitment. And you got time to think about the commitment. Defendant's bond is hereby ordered revoked. I will adjourn the pretrial hearing to next week on the 22nd. And she can come here with a better plan than what she's got now. 9 a.m. on the 2nd. Court calls the case, People versus Whitney Mitchell.
Espels for the people.
Good morning, Assistant Public Defender Lauren Penny on behalf of Ms. Mitchell. State your name for the record.
Whitney Mitchell.
Thank you.
Your Honor, this was adjourned from last Wednesday when Ms. Mitchell was remanded. As the court knows, I requested that she stay out of custody so she can go to treatment that was kind of in process of being set up by the University of Michigan. I did want to provide the court an update. I've been fighting with University of Michigan records and HIPAA laws and all that good stuff over the last 5 business days. They won't tell me anything because of the HIPAA. So I haven't made much progress there regarding that appointment she had last week and the follow-up appointment. However, Ms. Mitchell and I have had multiple conversations since then. She did inform me that she was, and I got a little information about the program she was already set up in. There was outpatient treatment that she set up back in August. That is through the University of Michigan's addiction treatment program. She is also, they work it out with her work schedule because she works from 12 to 8. She would attend that treatment for 3 days a week from, I think you said 9 a.m. to 12. And she indicated that she didn't get really started in that program because she had to go file some paperwork through her job so she could have an hour missed and show up late because she was doing that program. She was behind on some bills and just didn't get that ball rolling. However, she was enrolled in that program. So today I would renew my request to release her. She is, if she's released, able to start that outpatient, from what you explained to me, outpatient program as soon as her boss signs off on that approval, that work exemption. She is very concerned about her losing her 2 jobs. She works at the University of Michigan full-time, 8 hours a day, 5 days a week, and then works 12 hours at Five Guys on the weekends from 8 to 8. She is concerned that if she loses her job, she will not have the insurance to cover her outpatient program that she did set up. So today we're requesting an adjournment of the pretrial and for the court to consider releasing her to that program. Again, I have not been able to get any further details. I even emailed the doctor directly and to see if they'd give me any information, but didn't get anywhere there. So again, we're asking for her release today.
Anything from the people?
Your Honor, as the court will recall, the last time that we were here, the court reviewed with the defendant her history of dilute and positive tests. I know the defendant has not had any violations on her scram tether at the time that we were here last. I don't know if it's still on or not, but I would ask that at any release, continue to include that scram tether And if there is a continued pattern of dilute tests, I'm going to be requesting remand until trial. This is an opioid sex offense. I'm very concerned for public safety, but I recognize that the defendant is somebody that needs to be rehabilitated, so that way the community can be safer from her. So I will leave it at the discretion of the court with the caveats of asking for continued electronic monitoring.
Anything you want to say?
Yes, last time you told me to think long and hard, and I've had 7 days to think long and hard, and this is not a game. I just want to get out and try to salvage my job and go to the 3 days a week treatment. And I apologize for not thinking, and I will have self-control and just go to work and do my drug test, come home.
The young lady on this side back, is she with you?
All 3 of them are with me.
Who do I have?
Mom, grandma, and that's my auntie.
Your grandmother showed up with you
last time. Now it's my mom, my grandma, and my auntie, but I'm older than her. So it's like I
don't need to know that.
I'm older.
When I look at him, you look older than all. Yeah, I said it. You're going to end up. Let me ask you this. Why do you think I locked you up?
BSing, me trying to beat around the bush. And like you said, 7 long days of being locked down for 23 hours. I thought about it. It's not worth it. You can literally lose everything at the drop of a dime.
Yeah. And you sat there. Not that people don't have answers for everything, but you had an answer and an excuse for everything that happened. And then you did the worst thing that you can possibly do with me. I don't know whether you knew it or not. And that is you try to use your child as a shield to stop something from happening.
That was stupid.
Yeah, you were.
I'm not hurting nobody but my family and my child by doing this.
Your grandmother was with you last time, and now the other 2 ladies that come down try to figure out what they're going to figure out what to do. Mom, grandma, you want to say anything? Who are you, ma'am? Either one of you, whoever wants to say something to me.
My mom probably, my grandma's probably too nervous.
I think grandma last time mentioned she can't hear very well.
Oh, she can. Okay.
She might,
Can we get her the? That might. Yeah. Does that help, Grandma? Yeah. Okay. Was there anything you wanted to tell me?
Well, I think that we need to go to treatment, to rehab. I think she should be in a treatment and stay and continue to go to a treatment.
Okay. All right. Thank you. Mom, was there something you wanted to say? Is that Mom?
I concur with my mother. Been working with my daughter a long time. I agree she needs help. I've been working on it, calling, so whether it's through the university or I have to come out of my pocket to find her somewhere to go. I'm committed to doing that because she's the only child that I have. So if you give her a chance, I put myself on the line. I know that's a lot. But I'm not going to give up. All I got.
All right. Okay, thank
And
you.
I said, yeah,
Huh?
that's right. Said the same thing that you said last week. I watched the entire thing on YouTube. Sorry, I wasn't able to come, but I work.
No, it's okay. It's all right.
But we've been having discussions for a long time, so you were right, she's been lying for a long time. But now that crap has hit the fan, she sees how it affects everybody, not only her. Hopefully, she'll follow through what she said, and you can start life, you start a dream.
Thank you. Somehow, although your mom wasn't here, somehow, when I looked at your grandmother, I knew what I was telling you, you had already been told before, probably repeatedly. So I'm not really clear, although I wasn't sure of that, I'm not really clear when you showed up here, why you decided that you thought it was going to work. I mean, I know I look stupid, but I'm really not. How many times were you testing a week?
Twice a week.
And at the outpatient program, she will be tested 3 times a week there as well.
Yep, 3 times a week.
Yeah, I'm gonna let you know I'm doing this in a lot of ways for your grandmother and your mother. I hear your mother very clearly. She's been trying. She's not going to give up on you. So I don't know them, but they seem like 2 very dear people. So if you let them down, fair warning, if you don't think I'm real, you'll find out. If you let them down, I'm sending you, and there's not going to be anything you're going to say to me. Are we clear?
Yes, Your Honor.
So what I will do is I'll adjourn this to the 5th of November, 2025 at 9. I'll set your bond at a personal recognizance. Your testing at community corrections will increase to 3 times per week. We'll take a look at that after you're enrolled in some type of treatment program of where that's going as to whether or not I'm going to let you test there and not test here, but I certainly want to. So you could potentially do 5, you could potentially be testing every day.
It's fine. I'm all y'all gonna get from me is juice and water. I'm not, yeah, this is serious. I need to keep my job and keep my place, and I'm tired of
You
hurting
know what?
them.
You keep talking about your job and your place. Here's what the real issue is, and what your mother is trying to tell you. You need to keep your life. It isn't about the job. It's not about where you're living. It's not about any of that. It's about just living. Did you hear the last thing your mother said?
She's not giving up on me.
She's not giving up on you, but she wants you to kind of work through this so you can have a life.
Yeah, it's not the life I've been living. It's really not a life.
No, it's not. And the problem is, and your mom knows this and grandma knows this, if you kept along the same path, you're going to end up dead. The only thing that they're going to be celebrating is your life at some homecoming ceremony or homegoing ceremony or funeral. And you need to understand it. That's how serious it is. There's not really a monetary value that you're trying to place on it. It isn't about that. Anything further?
Nothing further, Your Honor.
Did you put this right?
Are you on the scram now?
Yes, Your Honor.
All right, that will continue.
Thank
She's
you.
got-
Yeah.
Yeah, okay, thank you.
Thank you.
Thank you, ladies, for coming down. Do appreciate it.
Good Lord. I can tell you this from watching Judge Simpson. Don't use your child as a shield, but your grandma will work. Your grandma will work every time. Whatever. I understand where he's coming from, but she'll be back. That's just the sad truth of it. All right. There we go. Sorry, I didn't mean to have 3 streams, but that was really dictated by the trial. I had to know what was going on at the Bottoms Up and Bad Axe. I'm sorry. I just did. Thanks for coming out. I appreciate it.